What is qualified immunity?
The substance of constitutional rights is meaningless if state actors can violate those rights with impunity. Such rights will become, in James Madison's words, parchment barriers, symbolic commitments to individual liberties that do nothing in practice. The debtor will prevent unlawful misconduct by government agents. Unfortunately, most members of law enforcement operate today in a culture of near zero accountability. Police officers rarely face meaningful consequences for their misconduct, and the public's accurate perception of this fact has contributed to what can be best described as a crisis of confidence in our nation's law enforcement. And while this culture of near zero accountability has many causes, by far the most significant is qualified immunity. Qualified immunity is a judicial doctrine created by the Supreme Court that shields state actors from liability for their misconduct, even when they break the law. Under this doctrine, government agents, including but not limited to police officers, can never be sued for violating someone's civil rights unless they violated a clearly established civil law. While there is an amorphous, malleable standard, it generally requires civil rights plaintiffs to show not just clear legal rule, but prior case with functionally identical facts. In other words, it is entirely possible and quite common for courts to hold that government agents did violate someone's rights, but the victim has no legal remedy simply because the precise sort of misconduct had not occurred in the past or in other cases. In the words of Federal Judge Don Willett on the U.S. Supreme Court of Appeals for the Fifth Circuit, to some observers, qualified immunity smacks unqualified impunity, letting public officials duck consequences for bad behavior no matter how palpably unreasonable, as long as they were the first to behave badly. There are countless tragic examples of how this actually works in practice. But take for example, Orbit v. Vickers. In this case, it especially illustrates simple components. Police officers pursued a criminal suspect into an unrelated family's backyard, where an adult and 6 children were outside. Officers demanded that they all get on the ground. Everyone complied, and the police took the suspect into custody. But then, the family's pet dog walked into the scenes without any provocation or threat. One of the deputies started firing shots at the dog. He repeatedly missed. He did strike a 10-year-old boy who was laying on the ground still nearby. The boy suffered severe pain and mental trauma. He's lucky to be alive. He had to receive ongoing care from an orthopedic surgeon. Amy Corbett, the boy's mother, brought a civil rights suit against Michael Vickers, the deputy who shot her son. But Vickers, the court that dismissed the case because qualified immunity. District Court judge actually denied this request for the sensible, seeming reason that unlawfulness of this conduct should have been very obvious to every objectively reasonable officer in Vickers' situation. A panel of appellate judges reversed the decision. Vickers was entitled to qualified immunity because no prior judicial decision involved the unique facts of this case. Corbett's family was left without any remedy. From a legal perspective, qualified immunity is especially controversial because, in addition to being illogical and unjust, doctrine fundamentally unlawful. Logically, qualified immunity is supposed to be an interpretation of a primary federal civil rights statute, codified in 42 U.S.C. Section 1983, and thus generally called Section 1983. Statute, first passed by the Reconstruction of Congress as a part of the 1871 Ku Klux Klan Act, itself was part of a series of enforcement acts designed to help combat lawlessness and civil rights violations in the post-war South. The statute itself is straightforward. It says, any government agent who violates someone's federally civil protected rights should be liable to the party injured. In other words, in Section 1983, it allows anyone whose constitutional rights are violated by a state actor to bring a lawsuit against them in federal court to get damages for their injury. And even as the federal Supreme Court has acknowledged, the statute on its face does not provide any immunities. Where did qualified immunity come from? The Supreme Court has primarily justified The doctrine as an interpretation of common law immunities for government officials were supposedly a well-established section of 1983 was passed in 1871. Where, according to the court, these immunities were well understood background legal principles at that time. Though the law itself says nothing about them, they should nevertheless be understood to apply to the statute. To be clear, there's nothing wrong with this sort of argument in principle. Suppose a legislature passed a statute that said, a person who willfully discharges a firearm at another shall be guilty of a felony, prison for not more than 10 years. It says nothing about an exception for self-defense. Self-defense is a such well-established part of our legal tradition that the courts would probably assume that the legislature did not intend to negate it. The problem is that a historical matter, 19th century common law, did not actually include anything like the sort of the broad defense for all public officials that characterize modern qualified immunity. A scholar on this subject is Will Baude, a Chicago Law School professor. His recent article demonstrated that the background of the legal rule, both founding era and throughout the 19th century, was a strict liability for government agents who committed constitutional violations. In other words, if a government agent was sued for harm that they caused in the course of carrying out their duties, it was no defense that they believed that they were acting lawfully. To be sure, there were certain good faith defenses in the 19th century common law. There's some disagreement about their scope. Todd argues that good faith was generally only relevant when the lack of good faith was an element of a particular claim. At law, if someone brought a false arrest suit against an officer, show the officer wasn't in fact acting in good faith. Rule was simply a part of the common law element for false arrest claims because of good faith as a general defense for public officials. The upcoming article by Scott Keller, a former Solicitor General of Texas, argues more broadly that 19th century government officials enjoy freestanding immunity for discretionary acts, what was then called quasi-judicial immunity, unless they acted with malice or bad faith. Will Baude has already posted a response to this piece, in which he argues this sort of immunity only applies in protected quasi-judicial acts like election administration and tax assessment, not ordinary acts of law enforcement. But even Scott Keller agrees that 19th century common law can't justify modern qualified immunity for one key reason. Qualified immunity today is not a good faith defense. A public official will receive qualified immunity unless they violated a clearly established law. But this standard has nothing to do with the fact that whether the defendant was actually acting in good faith. All that matters is whether the facts in the case are sufficiently similar to facts of prior decision. The clearest example of this point is another case called Joseph v. City of Fresno, in which the Ninth Circuit granted immunity to police officers who were alleged to have stolen over $225,000 in cash and rare coins while executing a search warrant. Obviously, these police officers were not acting in good faith, and no one contended otherwise. But the court said the theft of personal property by police officers sworn to uphold the law may be morally wrong. The officers couldn't be sued for the theft because that particular appellate court had never specifically decided whether the theft of property covered by the terms of a search warrant and a seizure pursuant to that warrant violates the Fourth Amendment. So because there was no prior case involving such outstandishly illegal misconduct, the officers received qualified immunity, not to mention $225,000 plus goods and cash right in their pockets.